What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And last week, if you had followed me on X, I made a presentation at the Sports Lawyers Conference, the session on academic research, and presented my paper, The Ollie Act and Why It Needs to Be Fixed and Expanded. I had indicated that I was going to post the video of my presentation, but I realized that I am not a videographer, and recording it on my phone really didn't help, especially since I had it at the back of the room, and also because the echoes in the cavernous room would kind of muted out things that I was saying. So I instead of posting that and having multiple people say they couldn't hear me, I thought I'd give my PowerPoint presentation and explain it here on YouTube on the legal submission. So, interesting enough, just a little bit about the Sports Lawyers Conference. It's a conference for sports lawyers. So the one session that I presented the paper on was a lot of law professors, mainly, everyone except for me was a law professor, and they presented papers of their scholarly work, whether it's qualitative, quantitative, or something in between. Notably, I would say a good percentage of the papers, there were eight, I think six, had to deal with the name, image, and likeness issue that is going on in U.S. college sports. There were multiple different varieties of takes on the NIL, and I thought that was very interesting. Mine was the only one on combat sports. Combat sports still is a niche sport in sports law, but I think that with what is going on with the UFC and the continued proliferation of boxing, I think that in years to come, it will be a part, once again, of U.S. viewership. So moving right along, I gave a brief introduction of the Muhammad Ali Boxing Reform Act, signed into law in 2000, amending the 1996 Professional Boxing Safety Act. There were three stated purposes for it: protect the rights and welfare of boxers, support state boxing commissions with the oversight of the sport, and promote honorable competition in professional boxing and enhance the integrity of the industry. One of the things of the multiple items of the Ollie Act is that the Ollie Act mandated firewalls between managers and promoters, protecting boxers from coercive contracts and requiring disclosures regarding the bouts that they promote. More on that later. The other two things that I wanted to highlight to the individuals in attendance was that there are penalties which include money damages, court costs, and reasonable attorney's fees and expenses affixed to the Ollie Act. There are also criminal violations that may include not more than 1 year in prison. We have never seen anything like that enforced with the Ollie Act. I then gave a brief synopsis on who runs combat sports. In boxing, we have sanctioning bodies: the World Boxing Association, World Boxing Council, International Boxing Federation, and the World Boxing Organization are the bodies which have the titles for which boxers try to retain. Most try to retain. Boxing promotions, as we all know, include Top Rank, Golden Boy, PBC, Matchroom, and then there are others as well. But it's the promotions that sign the fighters and get them deals with fights with sanctioning bodies. As we all know, the overarching career goal for a boxer is to make the most money. And through that, the sanctioning bodies have rankings, and it is the hope of a boxer to rise in the ranks and then obtain the title in their particular weight division. So these sanctioning bodies would have them win the title. If you are a title holder, it's inferred that you make a lot of money which as I indicated, is the goal in combat sports. Who runs combat sports and MMA? Well, realistically, there's just one. I had listed in my original PowerPoint that it's Bellator and the UFC, but thinking about this more, UFC is the sole promotion that runs MMA. Now, they do work with the state commissions, that is true, but in all honesty, it is the UFC that has the most influence in the sport of mixed martial arts. State commissions rarely stand up to the UFC. Moreover, it's just the commissions that quote unquote work with the UFC. It's rare that these commissions will prevent the UFC from operating in its state for a variety of reasons. And for a variety of reasons why the Ali Act is does not have the bite that it should have. And the fact of the matter is, state commissions do not have the necessary budgets or the necessary people in its employ to help work with promotions and enforce the rules and regulations of the state. Now, I then move on to the case of Mladen Miljas and his dispute, which occurred actually early in 2023. He was a 25-year-old heavyweight from Mississauga, Ontario, Canada, when he signed with Greg Cohen and Greg Cohen Promotions. He was a good fighter, amateur record 17-3 according to BoxRec, pro record 8-0 at the time he signed with 8 knockouts. And I find this notable. He had a quote when he signed with Greg Cohen saying that for a long time I didn't have anyone arranging my fights, so it feels really good having someone on my team now. I'd like to be active and fight every month if I can. And that is dated August of 2018. Well, as we know from the case, if you have been following, that did not happen. Miljas had a dispute with Cohen about the number of fights he was taking and the quality of those particular fights. He had sent a notice to cure a breach of contract. The breach is on Cohen's side. Cohen disputed that there was an actual breach between himself and Miljas, and there ensued the lawsuit, which was filed in Iowa Federal Court. Now, one of the things that I brought to light in the Ali Act and during the discussion was the fact that the jury had to ask the court meaning the judges, about how to assess damages in light of the Ali Act, meaning how do you prove, did the plaintiff side, did Mladen Miljas' attorneys prove their case according to the Ali Act? Now, the statutes usually dictate what you have to prove or what is necessary, what's been committed or omitted in statutes. The Ali Act, if we were to look at this particular example, did not provide that. And in fact, the court and the attorneys on both sides did not know how to answer a question asked by the jury. So the court and the attorneys were stumped. The jury did award $0 for the Ali Act claim, which was a little surprising considering the first question indicated did Greg Cohen commit a violation of the Ali Act? So the answer was yes, but the jury awarded nothing, which is a little bit befuddling because if you committed the violation, you would assume that there was some sort of damage, but that was not the case. However, they awarded $200,000 in punitive damages to Mladen Miljas. So no actual damages attributed to the claim, but $200,000 in punitive damages. Now, the punitive damages is great from Miljas' perspective. However, if you are in a jurisdiction which does not have punitive damages, you may be in trouble. So again, the jury verdict. Greg Cohen, his company was proven to have committed a violation of breach of contract, breach of a fiduciary duty, breach of interference with prospective businesses, and that totaling over $1.5 million plus attorney fees and costs. So therein lies one of the first and only cases in which a boxer prevailed over a promoter, and in such a big way, and also applying the Ali Act. And that happened last year. UFC antitrust lawsuit. I talked about a little bit just because in context it made sense. We all know about the lawsuit, the issues with contracts, and the monopoly claim. And essentially, I go on to discuss the issues related to the contracts in an attempt to make the Ali Act have a little more bite for the enforcement of it, as well as including mixed martial arts fighters. There were hearings on the Ali Act expansion, and as if you follow me, I talked about that in depth, and those happened in 2016 and 2017. So where it was the first real public attempts to make changes to the Ali Act since its inception. As we all know, nothing happened despite the fact that there were hearings. We saw different viewpoints from the UFC and Bellator. The different viewpoints being that the UFC believed that it was a federal government overreach. Commissions were better suited to deal with their own state's matters, and I believe Mark Ratner, who was the individual testifying before this subcommittee, indicated that they were dealing with boxing and needed the Ali Act because of so much untoward business dealings, unsavory business dealings that went with it. Bellator, on the other hand, they believe that there was a they supported the act, but they did not believe that the act should be amended in a way which would take away power from the state and tribal commissions. They once again believe that the commissions, state commissions, should have authority. They also stumped for the fact of the long-term contracts were good on the part of the promotions and helping foster a relationship with the fighters and helping develop a marketing plan for the particular fighters. So what were my suggestions for the Ali Act? Well, the one thing that has been pointed out multiple times is the fact that there should be an administrative agency dealing with the Ali Act, which just is not going to happen. There's too much going on in government to even get an Ali Act, a proper hearing. We probably couldn't get a government agency. There should be ADR in these contracts. One of the things is that boxers don't have money. MMA fighters don't have money or legal costs to fight a promoter or manager in court. It's rare that you see things like the UFC antitrust lawsuit, which lasted over 10 years, or which lasted about 10 years, to get to a place where they can get a decision. The Mladen Miljas case, again, is one that I highlight because it went to a decision. They had attorneys on the heavyweight boxers' side. Sunset provisions in contracts. We've talked about this with the Francis Ngannou case. Ngannou, instead of renewing his contract with the UFC or having additional fights tacked on to his contract, he simply let the contract expire after 5 years. Now, the one thing that I'd like out of all these suggestions is opt-outs for contracts on both sides, similar to baseball or football or basketball, there's an option. There's an option, and I would propose an option after 2 years. Gives the fighter enough chance to prove himself, gives the promotion enough chance to decide whether or not they like the guy or gal. And after 2 years, either side can opt out of the contract. If the fighter is doing really well, he could just opt out and be a free agent. If the promotion believes that the fighter is not doing well and losing, they could also opt out of his options and no longer offer him any more fights. Require state commissions to disclose fight purses and also attendance and gates. Now, I believe that this is a part of the Ali Act that isn't really talked about, and that's the fact that a promoter has to tell a boxer or boxer how much they are making off of them, and there is the argument that it's hard to know, especially if there's a pay-per-view, what's the total amount. So there would be, I would suggest a required disclosure amount as well as a disclosure amount for the venue to determine how much they are drawing. And that helps the boxers and the MMA fighters get an understanding of what they are worth. Stiffer penalties for sanctioning organizations. This relates to more of boxing, and that occurs where there is just egregious or untoward thing that a sanctioning body has done. If it would prevent fraud, it would prevent payola, and knowing that they could succumb to some sort of penalty would prevent them is a method of prevention. Treble damages for the Ali Act. Now, this is similar to the antitrust cases where there's treble damages as well. I believe if the Ali Act were to have some sort of provision granting attorneys the opportunity to make more money, they'd be more looking into taking cases on behalf of combat sports fighters. And with that is all I have.